Hi, my name is Luisa De Moraes Azenha, and I'm a PhD student at the Berlin Graduate School of Social Sciences at the Humboldt University of Berlin. And my PhD topic is on assessing the effects of crowd law initiatives, experiences from Latin America. And my presentation today is on the epistemic value in crowdsourcing legislation, a case study of a consultation on the Brazil Civil Rights Framework for the Internet. So I'll start by giving a short introduction on the epistemic value in democratic deliberation for policymaking. Then I'll talk about crowdsourcing as a tool for deliberation. Then I'll get to my case study, which is on a crowdsourced consultation on the Brazil Civil Rights Framework for the Internet, and the epistemic gains that it engendered. So I'll start by sharing some information on the case, then talk about the methodology that was implemented, and then share some preliminary findings. And I'll finish with some conclusions and final remarks. So I, first of all, assume that there is epistemic value in democratic deliberation for policymaking, and that the exchange of different points of view, values, and information can help participants select the strongest or most relevant amongst them, generating synergies between individuals. And that these synergies in turn can be used to develop innovative solutions for common problems, reshape opinions on the issue in question, and possibly lead to consensus. And that therefore deliberation can promote a more informed and active citizenry, while also giving decision makers the opportunity to apply these solutions or select from different arguments and information to propose more effective and efficient public policies. So crowdsourcing is probably a term that you're all familiar with by now. Can be defined as an online distributed problem solving and production model that harnesses the collective intelligence of online communities to meet specific organizational goals. So crowdsourced deliberation combines the qualities of deliberation, of offline deliberation, with the properties of crowdsourcing, enabling an asynchronous, distributed, and depersonalized exchange between participants. And crowdsourcing can be used by decision makers as an efficient means to access the public's opinion, experience, and expertise in order to produce stronger and more effective policies. So by being an online tool, crowdsourcing has the potential to reach a wider and more diverse audience than through offline channels with fewer resources, and therefore identify the main issues and problems in society and develop policies that can address them better. So with my case study, which is a case study also that I'm studying in my PhD project, I wanted to understand if there was any epistemic value being generated or that was generated through this platform, and what were these epistemic gains. So the consultation was created to discuss and elaborate a draft bill that would eventually establish the rights and duties of internet users in Brazil. So this consultation was created in October 2009. And it was a result of public pressure, mainly from internet activists, that reacted to a cyber crimes bill that was being discussed in Congress at the time. It was created by the Secretariat of Legislative Affairs, a branch of the Ministry of Justice, and developed in two phases. So in the first phase, the discussion was on the principles that would guide this law, and then the second phase on the content of the law itself. It sought the strongest arguments based on technical expertise. And the final version was written by the Secretariat, members of the Secretariat, with the support from experts from the Center for Technology and Society. So it ended in May 2010. It was introduced in Congress in August 2011, passed in the lower house in March 2014. And a month later, it also passed in the Senate and was sanctioned by the president at the time, Dilma Rousseff, and regulated in May 2016. In terms of participation and participation results, 686 topic-related comments were written on the first phase and 1,295 in the second. And there were 331 single participants in both phases altogether. In terms of the methodology, I combined a documentary analysis on the reports and existing studies on the consultation and on the other phases that this law went through, with 33 semi-structured interviews with diverse actors that were involved with this process, with this consultation. So with former members of the Secretariat of Legislative Affairs of the Ministry of Justice, who were the initiators and administrators of the consultation. Then also with members of the Ministry of Culture, who were responsible for adapting an existing blog that would host this consultation. Members of the Center for Technology and Society, different participants, so just citizens, members of internet activist groups and collectives, members of the Brazilian Union of Telecommunication Companies, as well as a representative of Google, the bill rapporteur in Congress and his staff, other stakeholders, so from the Brazilian Internet Steering Committee, for example, the DA's office and the Office of the Presidency, and finally also academic experts who also studied the Brazil Civil Rights Framework for the Internet. And these interviews were then transcribed and coded on MaxQDA. So I identified different epistemic gains, to be precise. First of all, the consultation was a valuable source of information, of expertise for the initiators. And 5 of the 34 articles present in the first proposal either had their wording changed or were erased during the consultation process due to the arguments that were presented by the participants. There was also a lot of peer learning on the topic itself and on the lawmaking process in general. So one participant said that it was because of the knowledge that he gained during this consultation, during this discussion, that he is now debating an active person in the debates on the general data protection law. And another interviewee said that he didn't know anything about law and that he studied in order to participate and to be able to discuss with other lawyers. Then the consultation also played an important informational role for Congress, for congressmen and women, and especially for the rapporteur by strengthening access to independent information. So a member of the bill rapporteur staff said that for the deputies who were on the fence in relation to some specific technical issues, it was a positive contribution, a positive a source of information. This consultation will also help map the different stakeholders and their different interests. So it shed light on the dynamic of interests of each agent, each sector, each stakeholder in the elaboration of the bill, information that was until then fairly unknown. And I also identified some wider impacts that stem from the consultation. So this transparent exchange of arguments and this very clear map of different actors and interests also help prevent hidden interests. So for a member of the Ministry of Justice, an administrator of the consultation said that they received a large association that disagreed with the law, that they shared documents where they stated that they were against it and why, and then they digitized it and put it on the webpage with the other contributions, and that this was later withdrawn. It was also used by the rapporteur as a shield against modifications in the proposal in Congress. So Luisa De Moraes, who was the rapporteur, said that the strength that the project gained as a result of this process was very important in Parliament, that it made a big difference from the point of view of the legitimacy of the project. So this identification of the different actors and their interests also helped build an alliance between the actors who supported the bill. So in an interview with the initiator of the consultation, he said that perhaps the greatest advantage of it being an online initiative was the forging of an alliance based on arguments. And this was this alliance was very important because it was an ongoing pressure to approve the bill, which finally happened a couple of years later. And the initiator of the consultation also shared that it also served as somewhat as a shortcut for negotiations. So he said that it also had the advantage, being online, that at a physical meeting, you normally have to respond immediately to a proposal or to an argument. But that in this case, it was possible to discuss with other members of your group or with other actors, and then come back with a response. So finally, my conclusions and final remarks is that this case further supports the claim that deliberative crowdsourcing initiatives can generate epistemic gain, create synergies between participants, and function as a valuable channel for decision makers to collect expertise and design more technically robust and legitimate outcomes, also in this lawmaking cycle. However, it's important to take into consideration that this consultation was implemented in 2009 and 2010, in a moment where the internet was not very accessible in Brazil, which helped in a few aspects. So there were fewer stakeholders and experts on the internet. Therefore, it was easier to reach the existing ones and to also reach some level of discursive representation. There were also fewer contributions to process, which is a huge problem nowadays, still for crowdsourcing legislation processes and initiatives. And finally, there was less polarization and fake news and their implications for deliberation. So that's it. Thank you very much.